we wanted to jump in. I wanted to introduce Daniel Goldberg. He is our guest expert today, and I know that some of the topics that we were interested in exploring last year was AI in particular, and this is actually a session on sort of what we're calling the legal implications of AI and some of the more recent developments about really what's happening in that space, since the word today is used in so many different ways, and so just trying to really wrap one's head around it. It's reminding me of the early days of the internet. Like, what does that really mean? Website, internet, AI. And Daniel is currently chair of data strategy, privacy security group at Frankfurt, Kernet, Klein and Salz, and he specializes in privacy and data security laws. And really, he is an expert in this, particular field. But he is not as an entertainment lawyer, so he's not the one to go in and talk about like how does this impact, this actor's deal or this producer's deal. He's here to sort of talk at a higher level of what's going on in the space. I want to be, but I could let you introduce yourself, Daniel, a little bit more than how I just did it.
No, I think that was a great introduction. So hi, everybody from Los Angeles. Good morning. I guess technically now it's good afternoon for those of you that are not in LA. I'm Daniel. As Holly noted, I am chair of the data strategy practice at Frankfurt Kernet. Frankfurt Kernet is a firm that really specializes work in entertainment and advertising, so you may be familiar with us. So I have a lot of partners that are dealing with some of the issues more on the contractual side around talent. But when Holly and I came together, we've actually given a similar presentation to this before. And Holly, I think the first time we did it was like 6 months ago. And one of the big issues was that there has just not been this much discussion around it. Like, I mean, there's discussion around what are some of the obligations around AI, but very few people are actually involved in the deal making and what the implications are. So today we thought it would be helpful because, again, I come at it more from a privacy compliance background, so I can talk to you about what's really going on, really specializing in that. I have some awareness of what's going on with like copyright, the MCA, but that is not my expertise. My partner, Jeremy Goldman, is really the expert on that. And I also can tell you about some of the laws that do impact talent directly, and California is the leader on this, and we have some new laws taking effect that just took effect at the beginning of January.
But on that one, I also just wanted to interject a bit. It was interesting when I was first asked, as I did with the digital entertainment group and the TV of Tomorrow. But when I was first asked, when I did ask some of my friends, because I think for all of you know, I call myself a recovering lawyer. And so when I was a lawyer, I was an entertainment litigator and worked for an entertainment firm. So when I asked some of my former colleagues and friends that are in the space and that actually do deals even on the studio side, they're very much relying upon SAG-AFTRA rules, and they're really just doing what when I used to practice, I would hold back rights. They're not really, and these are people that actually represent very famous actors. They're saying that you don't get this right. They're not really addressing what it means. Right? They're granting it or they're holding it back. And I would say far more on the latter. So that's why leaning into Daniel's expertise, sort of understanding the broader landscape, I think is very helpful. It's a good 101 session, so to speak. So on that front, let's just even go into there's even a confusion as to what AI is. And, because I feel like, we've been dealing with AI for a long time, but it's really just the LLM. And so why don't we just even discuss at the highest level, I feel like, Maria in Sound of Music, like the doe deer, the ABCs of what it is, and then understanding even and how we're building models, etc.
Holly, before you start, I actually would like to remind everyone this session is being recorded, and we're thinking about either sharing with the other peer members or posting it on LinkedIn. So just like FYI. So I'm going to edit the video a little bit, but just wanted to remind everyone of the recording. Perfect.
Sounds fantastic. So I think to start here, what Holly was saying is just to give a little bit of a high level overview about what are we talking about. So artificial intelligence is not a new concept. It's been around for while now, and in deal negotiation and contracts and technologies that many of the companies have, but they've been using AI for a long time. It's just all of a sudden it's become the hot topic, and that's really because of generative AI. And that's really because of what we've seen, when ChatGPT became such a big thing, what was it, like 2 years ago, and it exploded. And all of a sudden, everybody saw it and said, oh my goodness, like this has implications to revolutionize everything. And I'll tell you, frankly, I was shocked at what the capabilities were of the system, because, you look at it, and even from a legal perspective, I can search something so fast now that reduces the amount of time that's needed for anything. So, AI as a general concept, and when you look at ChatGPT and ask it, like, what is AI? What is an LLM? Here's what it comes up with. It refers to the simulation of human intelligence in machines that are designed to think and learn like humans. And there's a lot of different elements to that. To Holly's point, there's a term called LLM, which you may have heard before, large language models. And what an LLM is, essentially, is it is a huge amount of data that is brought together that creates human-like text and responses, and is based on a concept of deep learning algorithms. So again, very sophisticated uses of data at a significant level to produce outputs that can mirror human interaction level, simulate humans. So the reason why AI has become so big in the last few years has become that, again, there's been AI for a long time, but we've reached this critical mass point where there's been so much data that's been assembled over the years to allow these systems now to interact at a place that really gives human-like responses to things. So we're seeing this across all different industries right now. We see it, of course, in the entertainment sphere. We see it across the technology sphere, and it really has the ability to transform, life as we know it in a lot of respects. So that's why there's so much awareness about it, is because the possibilities are pretty amazing with what it can do. From a legal compliance perspective, the issue is that we're playing catch up, like we do with a lot of things. So the law always trails the actual technology. So, and I know, Holly, we're going to get into this in a second. We can start touching base, but I think one of the big takeaways we're going to have today is, like, there's not a lot of law on this, right? There's different laws that could be implicated by it, but the actual law itself, like, we're just starting to have laws that specifically regulate AI, and a lot of it would be right now through contractual components and terms.
Well, can we go into a little bit of, even, because that is, when I was reading up on it, just sort of the privacy issues alone, are challenging. And I'm not surprised that there are going to be lots. In fact, I think I got myself into this with this other group, because I said I think it's all going to be sort of resolved in the courts. And I think it started with the Scarlett Johansson, case. And actually, I feel like she can, afford the lawyers to, go ahead and resolve the issue. But for the ordinary person, sometimes when I look at what AI can do and how it can just basically replicate information that's already out there and just out there for public consumption, like, how to protect the ordinary person, let alone the broader entity.
Well, why don't we start even before that, right, Holly, is just like the basics of AI when we're talking about the LLMs and everything. So the main concepts of AI is that you have input, right? It relies on huge amounts of data. And I think that's what you're talking about partially here, is, that there's these systems to be created have to obtain large amounts of data. And then there is the actual output, right? And that is the concern that we have too, where an output could look like a person, could create a response, and then there's all different types of potential copyright issues around what the output itself looks like.
Right.
So when we're thinking about, building these AI models and the regulatory concerns, a lot where this has come up in my world, thinking about data privacy protections and issues, is that the input itself could be data that is regulated. And there's questions about when the data goes into these models and is used for purposes of generating the output, what is the legality around that data?
Well, ownership as well.
And ownership, exactly. So the big area that we're seeing, where I'm really seeing like the biggest concern right now is around training of these data sets, right? Data that is going in, that is being ingested in order to create these LLMs, and there's all this training data. And so, and training data essentially is the data that's being used to develop these LLMs. And the question is like, where is this training data coming from? And the answer is from all of us, right? And so training data is coming from social media, it's coming from what's on the web, it's coming from public databases. And so you really have, when you look at the top LLM providers, there's really several companies that are at the top, right? So you have ChatGPT, which is OpenAI, you have Microsoft, you have Amazon, you have Meta. Some of them have open source versions of AI, but they have ingested huge amounts of data in order to train their models. And this is one of the big concerns that we're seeing with a lot of publishers, is saying, well, you were using our data sets in a way that was not legal. You did not have the rights to be able to use our data. So we've seen a number of lawsuits that have, happened in the last probably year and a half, 2 years. There's a big lawsuit by the New York Times against OpenAI, and many different companies have been bringing these publishers with concerns about misuse of data in a way that, again, is not legal or violates their contractual rights.
Not to mention sometimes, whether or not it's even viable data in the first place. Poopy data in could be like, poopy training data out.
And that's a whole nother, exactly, that's a whole other concern, is like the quality of the data. So like when these LLM providers are looking for data, they're also trying to figure out, like, is this a quality data set? And the better the quality of the data set, the more likely they're going to want to use it, and the more they may be willing to pay for the data, which is a really interesting thing with these licensing deals. And so like that's a big thing that I've been working on, have been these licensing deals for training data sets. And Holly, that's something you and I have been talking about for the last 6 months, which has become such like a really hot topic, is around training data, especially in the entertainment industry, using data that you have that's in private databases in order to provide to these LM providers in order to train their data sets. And what do those deals look like, as opposed to saying, okay, well, you're going to use it in a way that's illegal.
Right. And I was actually, for this group, I was going to bring on a friend of mine, Dave Davis, colloquially just sold his company to Protege, and that's what they're doing. They're getting the rights to various, stakeholders script. And actually, he's focused on audio-visual content in order to sell to the training, for training purposes. A lot of the major companies are doing it on their own. And then, of course, we also saw what Lionsgate was doing, as well as I know that Cineverse also announced at the end of last year that they were setting up something sort of similar. And Lionsgate has a deal with Runway. Cineverse is actually setting up their own kind of like for training and actually acquisitions as well, sort of a competitor to Protege. But and then the other issue was even the economics involved with that, like how much are people willing to spend? And it's a very interesting prospect. Certainly, if I were owning a lot of scripted data, or any honestly, in a world where companies are struggling to make money off of the libraries that they have, this is a good area of opportunity.
Absolutely, and that to me is actually one of the most interesting things I've seen about these deals, has been that the valuation has been all over the board. And I think, it really goes to the quality of the data sets. One thing you and I were talking about was around that also it is dependent on the jurisdiction. So, it could be for entertainment content that is in the US, but it could be international content as well that's being used. And whether or not it's video data, whether or not it is, think about it like a library of sources. You have scripts that you want to be uploading, you just have all this data that's been sitting in your archives that you're kind of like, there's no value to this. There's this concept now that you can monetize that data, because that data can be used by these LLMs. But on the other hand, the concern that you have, right, is if you're going to be licensing out this type of data for these purposes, you have to make sure there's sufficient restrictions. And then there's also questions about, like, in the long run, with these LLMs becoming so powerful, is that something that could eventually replace the monetization of your company in general? and allow them to replicate the services that you're doing. So really big issues that everybody's thinking about, but this is the very, very beginning. It's, it's like the Wild West. And so again, there's just not a lot of legal, it's mostly in contract at this point. And there have been claims, to my point, and I won't get too deep into this, but my partner can talk more about it if anybody has other questions later, around the legality of the copyright issues. And what's happened is that there have been claims that these LLM providers have had that when they're ingesting lots of data without having a licensing agreement, that it's subject to fair use. And I think the best analogy to think about this claim is to say, well, I'm going to a library, I am checking out a book, I'm reading the book, right? And then I'm checking it back in. I'm not keeping a copy of the book itself, but I'm learning, I'm ingesting that learning information, and that goes into the model. So that's the argument, is they're saying, well, it's really akin, it's not really taking the actual data itself and replicating it, it's learning about it and to improve the systems so that therefore
that's fair use in the copyright realm.
Correct. And that's the interesting argument. And so we've seen a lot of judges have bought this argument and have, there's been motion to dismiss is brought and have actually said, okay, well, that's fine. But then there's also been situations where they haven't. And some cases recently where that's happened too, where they've allowed the claims to proceed. And so again, we're in the very early days about this.
I mean, just for this group, I mean, and for the like fair use, I'm sure you may or may be aware of it, but it really means it's kind of like when you're taking a course when you were in college and they were introducing someone else's like copyright or film or book, and you were able to integrate it into your own story because that was actually a fair use of the copyright law, and that's an interesting argument that they're doing it. Which case, it's a good segue into kind of regulation in the U.S. states versus globally, because you did mention the global component, which so many of like our clients are led by global, do have global platforms. So I'm very curious as to how that, what's happening first of all, and then just the what does that really mean? Like if Montana passes a law, like what does that really mean?
So the first thing I would say is, so again, I want to differentiate between the contractual issues and what we were talking about, copyright, and the regulatory framework. Right. The regulatory framework is more like, are there specific laws or rules limiting the way that this data can be used? Okay. And for purposes of regulatory framework, the landscape, really there has not been that much. That's the first bottom line, is that at this point, there just has not been that much. Now, there's a lot of interest in it. And this reminds me a little bit of like what happened with privacy when privacy was first coming out, is that privacy concerns were first coming out, is that there wasn't a lot of regulation around data use. And when I'm thinking about privacy, I'm thinking more about the way that data that is collected from your devices, collected from individuals, is used. We're not talking about like rights of publicity here, okay? So in terms of the way that data is used from your devices, there was not much regulation but in the United States. There was globally in Europe. And then those of you, on this call may remember, we got the GDPR, which I believe took effect in 2018, which really changed a lot of things. And that's Global Data Protection Regulation. And that put restrictions on the way personal data is used. And then after that, essentially, U.S. lawmakers looked at that and said, we're going to take concepts from GDPR, we're going to implement it into U.S. privacy law. And now we have 19 comprehensive state privacy laws that are either in effect or going into effect within the next year. So we moved pretty rapidly. In 2018, there were none. Now, going into 2025, we have a number of them. And most of the regulation is at the state level, not at the federal level. So if we look at what's happening with AI right now, there has not been a lot of regulation, but there's been a lot of talk about it, right? So at the federal level, there's been a lot of discussion. There's been proposed frameworks, and there's been some specific requirements at the government level. But really, we haven't really seen this trickle down yet otherwise. But what's really interesting, so things changed last year when Europe passed the EU AI Act. That is slowly taking effect this over the course of the next year or 2 years. and it's going to put restrictions around how AI models are used. But it's really it's not as focused on Gen AI. It's really focused more on like high level concepts around AI, and saying that certain types of AI uses which create discrimination are prohibited, etc. So it's far less granular than what we've seen in the States. Now what we're starting to see on the States is it actually one of the first AIs was in New York. It was an employment AI law focused on bias and discrimination issues. And then since then, California actually has become one of the leaders in the AI laws. And so this past year, Newsom signed a number of AI laws, some of which took effect in January. And that's actually what I was looking a little bit into right before this, because it is moving so quickly. One of the ones that I think is really interesting, which is going to be coming into effect next January, is AB 2103, which requires AI companies using Gen AI to publicly disclose data sets, disclose how to get the data to train their AI models. So I do think that's going to be really important for companies here that go, okay, well, how are you getting my data? You know, how is my data appearing in your models and everything? Now there's going to be a requirement for these large language models to actually disclose that.
So, but Microsoft, actually, Carrie has a question, but Microsoft won't have to because they're in Seattle.
Well, not necessarily. Okay, so this is to Terry's question, how are the state privacy laws solving conflicts in their language from state to state when they are regulating something online? Okay, so privacy law in general is based off of where the resident is located. So if you are a company that does business in California, but you're Microsoft and you're based in Washington, if you are collecting the personal data of a certain number of consumers that meets a threshold, that is where you're implicated by the law. So similarly, this is how this is read. This is how this is written in AB 2103 that says if you're doing business in California and you're collecting, data there, and again, there's certain thresholds, then you have to disclose where that data is coming from to train your models. So that, again, really interesting one. So yes, this does, even though they are online and even though it is specific to, certain residents of states, potentially, if you're doing business in that area, it implicates you. So that's why when I'm saying that there's 19 comprehensive state privacy laws, if you're a company even in New York and you're not based in one of those states, because you're triggering the elements of it by doing business there and collecting the personal data, you are still subject to that state's jurisdiction.
That's good.
Yes.
And then on a related note, we've been hearing a lot of, a lot of my friends and clients, they've been saying, well, we need to, have someone come in and start training our companies on how to, act ethically. There's this notion of ethics and using AI data ethically. So how is that, what does that really mean? And how is that really different? Is this a way of showing, I'm asking the question.
Yeah. So I know sometimes we talk about ethical and fair use can get mixed up. That they are different concepts, right? Fair use is a legal defense to copyright claims, saying that you have the right to do it. Ethics is really concerned around using models and data in a way that has fair outcomes. So ethical considerations, one of the big focuses on a lot of these laws has been to say we want to prohibit bias, discrimination against certain consumers. So good example would be, let's think it's like a correctional facility, and or somebody's in a prison and they are up for parole. If you have an AI system that is analyzing whether or not somebody should be subject to parole or not, and it takes historical data, it may make a decision based on the historical data that men of a certain demographic are more likely to be eligible for parole based on historical basis for that than perhaps men of a different demographic. But the reality is that might just be because there were more men of a certain demographic who were eligible for parole in the past. So it's not necessarily an ethical judgment. It is based on the inputs, and that's your point before, Holly. The quality of the input has a huge impact on the quality of the output, and also the way that these algorithms are trained over time can have inherent bias in them. So one of the big movements on these laws, and Colorado has a law that's going to be coming up, as does California's working on potential laws on that too. There's the California CCPA regulations that are proposed right now, but arguably potentially will take effect sometime in 2025. And that talks about, and this is where it gets into the kind of the combination of personal data and privacy with ethical concerns, is to say that if you have an LLM model and you could potentially cause discrimination for consumers or bias, you need to evaluate those models, and you need to make sure that you understand the inputs and the outputs, and you give consumers the rights to understand the basis for how the decisions of these models were calculated, as well as give an appeal potentially to consumers to say, we want to have a person who comes in here and actually looks at these models and make sure that, or the outcome, and make sure that it's actually a valid outcome.
Do you think there'll ever be a world where we're going to have to be, companies are have to be very transparent as to what that input is?
Absolutely. That's exactly what's coming. So a lot of what we're talking about is what we think is coming. And I can see a lot more than what we talked about 6 months ago. 6 months ago, Holly, when you and I were having this discussion, we're like, okay, well, there's some stuff. There's this EU AI Act, which has concepts of it. But now, as we're really getting more focused on what state legislatures are looking at, and we see, Holly, you and I were talking about it, that there is a ton of states that are looking at prospective laws right now. Even though we only have a few states, Colorado and California, which have really passed anything, we know that stuff is coming. Just like what I think is what we've seen on the privacy side, we're going to see this on the AI side, regulating, especially focused on the discrimination and bias elements. And so, yes, a big part of that is you're going to have to talk about the inputs. How did you determine that data is valid? What are the outputs? What type of audits have you run on that? And then to the other point I was saying here with this AB 2103, you're not only going to be having to look at personal data, you're going to have to be looking at data generally used to train the AI models and disclosures to say, where did we get that from? What were the third-party sources? How did we get the license to that, et cetera?
Interesting.
And then as we're talking about this, the other thing I just want to mention is there are some laws that have come into effect or will be coming into effect. Again, California's leading the way. One of them is a law relating to creating and distributing AI-generated deepfakes. That's a crime now, because that's become a big concern around the fact that you see these images. Another one is around requiring watermarking, and saying that...
Well, that was going to be my next question, like being able to watermark and be able to... That's got to be a thing that's going to happen.
So one of the requirements is going to be that if you have an AI model, and I do think there's an exception, when it is relating to entertainment industry. But generally speaking, if you are generating images or text, you're going to have some type of watermark in it to be able to distinguish that it was coming from an AI as opposed to a human. And that's the big, that's one of the big concerns, is it's indistinguishable. How do you demonstrate that this was an AI that this came from? And this is especially concerning with issues of fake news and content moderation. And I mean, Holly, again, you and I were talking about it, some of the news that we've seen even today from Mark Zuckerberg talking about changing content moderation policies on his platform, on Meta and Facebook. There's just going to be huge implications. And so I do think you're going to see more laws really requiring this type of watermarking in the underlying content. And then the other one, which just took effect, is AB 2606 of the California law, which makes contract provisions unenforceable if they relate to digital replicas in certain ways, unless there are specific requirements. So this is really applicable in the entertainment industry. So in entertainment, there's a lot of concern that now you're going to see these contracts where entertainers are giving away their likeness forever in perpetuity in their contracts that can be used by these AI models. And now there are provisions in the law that says that contract is not enforceable unless it is very detailed, set out, and that person, I think, has to either be represented by the lawyer or by some type of an industry trade group when negotiating that contract, because of the fact that, think about how valuable likeness is going to be, digital replicas are going to be moving forward.
Well, I think the notion of in perpetuity, that might be the issue too. It may not be something that they could do, and they might regulate the time frame. It's not going to be, it could be like copyright with public domain. There's a certain amount of years before it goes,
Exactly. So anyway, this is going to be, I do think, and that's AB 2606, that's a really important one for the entertainment industry, especially for those that are negotiating contracts with talent. And so I expect you're going to see a lot of that. And I know that, Holly, you were talking about a lot of the, and again, I don't know quite as much about this as my partners do, but some of the STAG-AFTRA stuff and other, requirements that we've seen around prohibitions around AI, a lot of that has been contract and industry led. Those have not been actually statutory requirements.
Well, again, as I was even referencing as it related to privacy, the deep-pocketed talent, deep-pocketed, platforms, they'll be able to, contract, or they'll be able to litigate. It's the ordinary person that sometimes, I get a little concerned about. I mean, as it stands, what we see on Facebook, you got a request, oh, don't answer, it's not me, it's somebody that's ripping off my, my Facebook. Or I can totally see that on LinkedIn, somebody going in and going into Jordan's, profile, LinkedIn, and becoming a new Jordan. How do you prevent that?
I mean, you already have issues with that, right? I mean, that all comes down to policies of the platforms. And again, I know that, and part of this is also optics, and I think we're going to have to get used to even more of this. There's chatbot disclosures as well, right, Holly? They're saying there's been requirements saying if you have a chatbot, let's say you're talking with somebody on whatever it is, you go to brand website and you're talking to customer service, if it is a robot that you're talking to, an AI, as opposed to talking to a person, that actually has to be disclosed now by law as well. So same thing, there are prohibitions that we're seeing in the law to say, well, you can't actually mimic a person fraudulently, through Facebook or otherwise, because again, that's problematic. And so I do think we're seeing a push on that, but that's more of a regulatory front on things. So again, there's just so many different elements here of AI. It's so broad, and there's so many implications in the entertainment industry, whether or not it's negotiating deals with talent, whether or not it's value of data in the back end. But I think, at least for right now, for those on this call, and we're talking, and to me, the training data element is really the value proposition that we're seeing in 2024, 2025. And then I think you're going to see a lot more constraints around the actual AI systems and requirements for those who are building the LLMs. And then those will get pushed down by contract to those who are using the LLMs around restrictions. Or if you're licensing training data, again, you're going to see more representations and requirements saying that you have the rights to give this to us. Because right now, I don't even know what those rights necessarily even look like when you're making those deals. No one does.
As we started in the beginning, I know that they're different. I mean, because we both know people that are doing it, and one is a rev share, one is a straight up dollar deal. So they're already there's not a lot of consistency there, not yet. This is amazing, and it's amazing. What's incredible is how much has changed even since the first time we talked about this 6 months ago. But for my group here, do you guys have any questions for Daniel? I know, Michael, you were probably one of the most interested parties here on this particular issue. Are you still on? Michael Park? No?
Sorry, I was in the other room. Sorry. Yeah, so I know you mentioned, Daniel, multiple times that currently the biggest, impact AI has is on the LLM learning and training models. Can you speak to a little bit about, how the New York Times sued because obviously they were training the model using this data, but they didn't have an agreement. But now there are all these agreements announced. So can you speak to how that's going to change going forward? Because, well, that's one. And then number two is the old library, right? Like Fox example or Disney.
Yep.
We have a lot of old library, and obviously those library deals and rights deals did not include digital because it was the time before digital. And some of that data would be right for training these LLM models.
Yep.
Can you speak to that old library aspect as well?
Absolutely. So to your first question, essentially here's what's been happening, Michael. For years, these AI models and companies have been scraping the internet to take data, right? And it's from news sources, from some of the largest publishers, et cetera, anything that's publicly available. And the reason why is that, again, to develop these models and to make them more accurate or to make them better, you need to ingest huge amounts of data. So what's happened is that all of a sudden you've seen, and again, I think a lot of this comes down to ChatGPT and making this information public suddenly, or Perplexity. You go on and you ask for you ask a question. You say, "What's going on here? Give me an update on the news." And then you see something that looks really similar to what the New York Times published. And then there's this question: okay, well, you are essentially not paying us for that, right? And so that's the basis of these lawsuits, has been concerns around saying, like, you're using our stuff that is behind paywalls and you're not paying us for it. So in response, we've seen a lot of these licensing deals. And it's interesting because when I negotiate these deals, they don't always call them licensing deals because they want to be clear they're not licensing the data. They're allowing access to the data for training and use purposes, but then they have to delete the underlying data set. And that was my library analogy before. So I think what you're going to see is that in the short run, you're going to see all these companies that are like, wow, my data can be monetized, and we can make a quick buck on this and a lot of money by instead of like fighting OpenAI and the largest technology providers, we're going to make good with them. So I think that's what you're going to see, Michael, is a lot more of that. That's how those interplay. I don't know what it's going to look like in the long run, right? Like in the long run, I wonder if, again, there will be backlash to say, well, we really, we didn't realize that your models were going to be capable of essentially recreating exactly what we do. And so that's one thing when I'm talking to companies and we're negotiating these deals, I say, you really have to understand the value of your data because you're getting a one-time payment up front, but that could, in the long run, have major impacts on your business.
Well, right. Because I mean, now, so many companies, everyone on this call knows is, we're, I would say it was a year survived to 25, but 24 was a year with, so much change and retraction and consolidation and a huge emphasis on monetization, which I could see a lot of people that have big libraries. And I know for a fact, as I said, I was going to even bring on, even with you, but I thought maybe I'd reserve it for another time. Dave Davis, who started Calliope, sold it to Protege. That's what he's doing. He's negotiating these deals. But, what one does in the time of, short-term focus on monetization, to your point, may have long-term implications. So I don't know, it's a deal, then it's like, they're annual, deals that automatically renew unless, we pull back our rights or, like there's got to be some kind of component there in the negotiation where they have the ability to be long-term, but you could put, you can terminate, at any given time, with a proper notice or something like that to protect yourself. You see it going at the wrong.
And I've seen them structured in all different ways. I've seen some that say, okay, here's a one-time access to our data. You can use this data for 6 months and then you're done. I mean, one of the things too is that these LM providers want access to the underlying data for a while because they don't just train it one time, right? They train it, then they test, and they may want to be able to use it again and again and again. So like, for example, I've looked at, there was one deal I was working on recently and it was around, potential license for 5 years. And it was also saying, like, you'll give us the most recent data over 5 years. So you get one lump sum payment at the beginning, but then they have access to your data for 5 years. I get concerned around a term that long because I'm like, well, I don't know what the regulations are going to look like. So your second question, Michael, around, you have this old library and you have all of these, all this library that's not digital and you want to digitize it. And then you go, okay, we want to license it for training because we know it's going to be really valuable. It wasn't contemplated in the contract, right? And so I think the biggest question right now is to think about what could be some of the contractual issues in that. Are there rev share issues that come up with the way the contract was originally written? And so a lot of this does not contemplate old media at all. It's going to be contractually driven. But I do think that as you see, as regulators start catching up, you are going to see more and more of these requirements. And again, the ones from California are the first example of companies must publicly disclose where they got the data to train their models. You may start seeing prohibitions that say if you don't have rights in your contracts for the content from the underlying individuals, you can't use that. for training models. I don't know. It's the Wild West right now, which is one reason why I think there's just there's a gold rush. I mean, everybody's saying, like, let's license this data out as quickly as we can because we might not be able to in 6 months.
Well, what's interesting, in our last meeting, Terry and I, we were discussing, the net profits and how deals have changed. When I first started this business and I was a lawyer, I did all the net profits, and that's when you did all the you can share in success of a particular program. And then there was a trend by Netflix where you bought it outright. Now it looks like it's shifting the other way. But based on what you're saying, it seems like it'd be better if it's bought outright and you get all rights. I don't know.
Maybe or maybe not. I mean, I think that, it really depends on what you're doing. Like, there's been discussion, right, with Perplexity, where now they are licensing data from the news sources in order to be able to provide, news, essentially, and there's attribution back. I think for something like that, that makes a lot of sense to me, where it says, okay, but the better question is, especially in the entertainment, like, it kind of goes into this black box. You have all this content that's being ingested. What is that really being used for? You're not really licensing elements. You're not taking elements of that and like saying, okay, we're going to like redistribute your exact, like a derivative of your version. Like, it's probably being used to create competitive content.
Correct. Michael has a question.
Michael.
Yeah, thanks. Thanks, Daniel. This has been a great discussion and really interesting. So it's the wild, wild west, and there's, not a lot of regulations and laws out there. So these, I guess my question is, who stands to lose the most? Who's in the most precarious position based on the fact that there's just not a lot of regulation around it? Is it the studios themselves, who on one hand are vulnerable, but also on another hand are benefit from AI, technology and AI advancements? Is it the actors and producers and directors who are kind of tied to these, individual IP? Who stands to lose the most? Who's in the most precarious position? And, who needs the most help from the laws, I guess, is another way to say.
Yeah. What do I think is going to happen? I think you're going to have, and it's, by the way, it's not just in entertainment, it's everything. I think, and in all professional services, I think you're going to have more of a extreme outliers on both sides. So I'll tell you, those actors who are the top actors that have a likeness that is worth whatever it is, think about like the Scarlett Johanssons of the world, they're going to benefit so much. They're going to make so much money on this type of stuff because their voice, could be in perpetuity, whatever it is, you're licensing that out. So I think you are a top level actor or a top level director, or you are one of the largest studios. And the studios, by the way, should be using AI. I mean, it's just like anything else. Think about when everybody moved to the cloud, and there was a lot of concern around the cloud. So to be clear, just really taking a step back with AI, I've been talking a lot about training AI systems, but there are ways to deploy AI in an ecosystem where, like, you don't have to use it for training purposes. Okay, you can use the underlying LLM to improve your systems and everything else. It's a tool that you can use. So I actually think you're a studio, you want to understand the metrics around your performance and be able to make better content and all of that. You could use an LLM and these tools to do amazing things. You can do it in a way to say, we need a lot less talent on set. We don't need to have so many extras because we can just create extras for that. We don't need to have dancers because we can create the dancers. Same thing again, as a lawyer, I say the same thing. I think if you're a lawyer and you've done, this for a long time and you know about it, there's going to be a need, for at least the foreseeable future, to have like the expert. How much do you need to have associates that are very junior to actually be researching this for you when you can just go on to Perplexity or wherever to figure this out pretty quickly? I don't know. So I think the winners will be those people that are already kind of established and are like at the top level, and the losers are going to be those people that are not yet known, that haven't been building up their careers. So I don't know. That's at least my thought here. But we're going to have to see. But I do think it's a positive tool that companies should lean into, because it really does help improve the business models. But at the same time, you have to be concerned about the specific consumer protection issues and, employment issues.
Thank you. Any other questions? I don't know. I think that was our 15 minutes then. What is the timing? I have a question on some of the, like some of the other laws that, do you have any sense? Because I feel like so much has already happened in the last 6 months. Do you have a perspective of when you think there'll be some additional laws rolled out, or, and this is something that people are going to be voting on, or that it's just going to be the governors are going to put into place? And then on a related note, but it's separated, when we talk about watermarking, there aren't many, are there companies today that know how to really do that? Because I know that there's some that are trying to do that in advanced advertising, to watermark, or to actually, also identify the truth, kind of marks. But if you're aware of any, that would be very interesting to kind of understand that component of it.
So with respect to timing, I would say I think this is moving very quickly. Again, I just want to give the example of privacy laws, where we basically went from California being the first one in 2020 to 5 years later, 19 states and counting. And many of those laws will implicate AI. California, again, the CCPA regs that are being proposed right now that likely will come into effect this year will have an impact on it. And as Holly, as you talked about, we know that, again, like 30 plus other legislators have been looking at this. And a lot of the lawmaking is now starting, like the process will start again in February and March for many states. So I would anticipate, and I know also Yuce has expressed, having more comprehensive AI regulation too, which he actually vetoed a law last year, which he felt was very comprehensive, but did not actually, it only really affected the largest LLM providers and not the smaller ones. And so that was the concern, is that it wasn't broad enough. So my answer to you is that I think you're going to see a lot of stuff happen within the next year. I think you're going to see a lot of laws signed this year, and they may come into effect either in January 2026 or January 2027. That's usually what we see with these laws. So I would expect that. And then with respect to watermarking technology, my understanding is, again, this is a big thing, and it's a big thing not just for content creation, but like think about like cheating with high schools and everything like that. So I know that there have been tools developed to address that. I believe that OpenAI has been working on tools to actually watermark their own content itself that comes out. You don't just necessarily watermark images, you can watermark underlying text or portions of text in ways that only machines can read it. So especially now with California law requiring this type of watermarking, I anticipate you'll see this in abundance over the next several years. I just don't know who's leading that charge, and there may be providers that end up being like the main companies that are helping with that underlying technology for the watermarking. But it's really interesting to see where we'll come of that.
Yeah, no, I'm fascinated by that part. And again, I know that it's something that's happening even in with advertising and advanced advertising. And final question, when we talk about the states, and we talked about EU, but we didn't really talk federal. And we're, going to have a whole new administration, and, that could turn, really impact all of this. Are you aware of anything to date yet, or do we think this is something we're going to know in the next 3 to 6 months?
So I'm actually doing a presentation on Data Privacy Day with a lawyer that I know who was formerly part of the FTC. And so this is a great question, right? What are the implications actually going to be at the federal level, like with the changing of the guard and stuff? There have been initiatives at the federal level to discuss it. And there has been some stuff around security and, again, requirements of the government itself. I don't know is the answer to this, whether or not. It's been like having the same thing with privacy law. There is not a comprehensive state privacy or federal privacy law. That's why we've seen all these state laws come into effect. And I think one of the questions is, can the federal legislature actually agree on putting together an AI law? We have seen the FTC regulate certain types of data practices under privacy, but arguing that, again, there was an AI issue, and there's also been advertising and marketing actions brought in connection with AI. So really interesting. It definitely, there is discussion of it, but there is not a comprehensive federal AI law at this time. But
I feel like this is like a tracker, like every few months
Yeah.
they adjust it. That's how much change is going on.
it's changing so quickly. So again, in 2 months, we might have a totally different discussion if we held the same
Well,
conversation.
Daniel, I want to thank you for your time. As usual, this is incredibly informative. I'm going to let you have your day. I'm going to ask those that are still remaining just in the last 5 minutes just to touch in for a second to talk about our next session. So, Daniel, thank you.
Thank you for having me. And if anybody has any questions, feel free to follow up with me. You can find me on LinkedIn. So
Yeah.
thank you, Harley. Really appreciate it.
Yetkin will send this to you. It's going to be recorded. And so we can all go on LinkedIn and see it again.